final speaker today is Gregory Hobbs, who's a justice of the Colorado Supreme Court, specializing in a variety of topics. Prior to becoming a judge, he practiced environmental, land use, transportation, and water law for 23 years. He's been on the court since 1996. He also serves as the vice president for the Colorado Foundation for Water Education, which provided some of the handbooks in the back, and is a co-convener of the Water Judges Educational Project, Dividing the Waters. He's the author of at least 10 books, and is known to give a very good talk, and we're excited to have you here, Justice Hobbs. Thank you.
Appreciate it. Well, it's a great privilege to be here, and especially since my wife just told me via email that I-25 has been closed down for ice in the Denver area. I slipped out this morning. Came over the Palmer Divide Monument in a fog. Reminded me of crossing the San Francisco Bay Bridge. I spent some time in Wren County as a kid. My dad was in the Air Force. Went to 12 schools by the time I got out of law school. So my wife is fourth generation Colorado. In her family, the women import the carpetbaggers. I'm pleased to call Colorado my home. But a lot of you came from elsewhere too, I imagine. And anyway, Colorado is anybody who's been here 3 months. Or maybe 30 days and has a right to vote. That's how I view Colorado. We all came here from somewhere else. You know, the Navajo tribe, I had a debate with the only PhD historian of the Navajo tribe one day at a workshop in Window Rock. And she's a very sophisticated woman and a professor of history. And I at one point said, well, the Navajo came in about the year 1200. They immigrated in. And she said, no, Justice Hobbs, you're wrong. We were here forever. So that will give you the idea of how all peoples believe they're here forever. But the fact of the matter is, oceans have come and gone, and we've all moved here. I think we need to be careful of our history and our rhetoric. And today I want to illustrate for you how Colorado's come to be formed around water. And it isn't just the homesteaders. It's the people of Mesa Verde who constructed at least 4 reservoirs we know of at Mesa Verde that were operated between 750 and 1180 AD. There were aqueducts built in Peru that are 2,000 years old. They were not built by Romans. They were built by Native Americans without CATs, PhDs, JDs, or other of these Ds. They were people that had to live in the arid regions. And through smart ingenuity and the tools which they had, they made and formed water structures, ditches, aqueducts, canals, reservoirs. These were not Mormons, these were not miners. Forget what you may have heard about the Mormons and the miners inventing the law of the West in regards to water. It is not. Water law is nothing more than the customs and values of the people over time, centered in community around the governance of the most precious resource we have, the water supply. So I've left on the table back there, if you haven't got it already, some 6 principles of Colorado water that are enduring because they're based on our Constitution and statutes. And the first one is that the water is always owned by the public. Okay? Always owned by the public. Second principle, it's dedicated to the use of the people through appropriation of unappropriated waters. That is water that's available for appropriation that hasn't been put to beneficial use by a senior. Third principle is that the actual beneficial use of the public's water resource is required for the establishment of a water right. Actual beneficial use. Not waste, not speculation. Actual use. Fourth principle, when there is not enough sufficient water to satisfy all use rights, the earlier established right prevails. The The earliest established right prevails in times of scarcity. Fifth principle, all persons and corporations are entitled to a right-of-way across the private lands of another for the construction and operation of a waterwork to get the water to its place of use. This is a private right of condemnation in our Constitution with the payment of just compensation. That's why ditch right-of-ways cross other people's lands, folks. Sixth principle. 3 years after statehood, the legislature put the courts of Colorado in the position of adjudicating water rights. The state engineer, the 7 division engineers, and the water commissioners enforce decrees. The answer, sir, to your question is, if you have a decree, you can have an enforceable water right. If it's a free river, there's enough water for everyone. All right? In times of short supply, you must replace the injury to the senior right to be able to divert and use the water. So it's not that a decree is useless. A decree is in the order of priority subject to the senior uses, the actual beneficial uses that have been made of the public's water resource. It is a valuable right, even if it's junior, because it can block a change of water rights. Changes of water rights are subject to decree when you want to move it from its prior use, typically agriculture, to another kind of use, recreation, municipal, in-stream flow, by taking part of the senior right and putting it back in the stream for the Water Conservation Board. All right? You have a water right, you can block the change of another that injures your water right. That is the primary function of a junior decreed water right, is to stop someone going up above you, trying to leapfrog and change, buy a water right and change it upstream, and it will cause you diminution of your water. It's not useless. The in-stream flow water rights, there are in-stream flow water rights on 9,000 miles of Colorado stream held by the Water Conservation Board, the most senior of which is 1973, when the law was instituted, but you can't take a water right and leapfrog it past other junior rights without protection against injury to the junior right. So you get fixed in priority by these water court decrees that are enforceable by the water officials and by us, the judges of the 7 water courts and the Supreme Court, the 7 of us, who get these water cases straight from the 7 water courts, bypassing our Colorado Court of Appeals. Now, the right in most other cases of direct appeal is only to the Intermediate Court of Appeals, 3 judges, and we decide what cases to take. In water, we cannot refuse to take the water case. We must take it. What other kind of cases like that? Death penalty cases. When the jury imposes the death penalty, we must take it. You got the picture? Colorado, water and death. Right? The metaphor. The metaphor, as Steve showed you, of the 2 irrigators with the shovels going at each other's head. We have avoided frontier justice. You must come before judges. Right? That's why you put the 3rd branch of government in this. And Colorado voters, by a 1966 initiative, took politics out of judging in Colorado. We're on the merit selection system. We don't run as Republicans or Democrats. We can't contribute to any political party. We can't take contributions from any political party or any person. We cannot have bumper stickers, yard signs, buttons supporting political candidates. We're out of politics because the people removed us from that, ironically due to a water case. In 1954, our justices of the Colorado Supreme Court were running as Republicans and Democrats. Chief Justice Mortimer Stone issued a very profound decision, 4-3 vote, upholding the rights of the Northern Colorado Water Conservancy District and the West Slope, our Green Mountain priority, against the city and county of Denver. Finding finding that Dillon Reservoir had a 1946 water right and the Green Mountain Reservoir on the Blue River below Dillon had a 1935 water right. Somebody on the court leaked the opinion in hopes of getting his colleague, Mortimer Stone, voted out a month before the election. The Denver Water Board, Rocky Mountain News, and the Denver Post proclaimed calamity. Denver would not be able to grow in the future because the West Slope of northern Colorado's senior priorities have been upheld for the Colorado Big Thompson Mountain Diversion System and the Blue River Green Mountain Decree, which is below Dillon but has a senior right. Mortimer Stone was voted out. The Denver Water Board filed for rehearing. Now you must understand, when a rehearing petition is pending, the new justice can serve on the court. I am absolutely convinced, and I've written an article about this, published in several law reviews, that the Denver Water Department felt that the new justice elected by their campaign in the press would vote and reverse the decision. To the everlasting credit of that justice, he refused to vote, and the decision stood. But the lesson was learned. 13 years later, the League of Women Voters, the business community in Colorado, and the Colorado Bar Association sponsor a successful initiative taking our judges out of politics. We don't have to spend a minute thinking about the political implications of our decisions. I will tell you that judges like the Texas Supreme Court justices who I talked to, who spend at least $12 million on their campaign, are thinking about contributions. How could you avoid that if you're in office and want to retain it? So there we go. I'm very proud to be one of your 7 justices, and the merit selection system in Colorado prevails: county court, district court, court of appeals, Supreme Court. Water matters are controversial matters. Some of your questions indicate the depth of it. Now, I'm a history graduate of the University of Notre Dame, a law graduate of the University of California, Berkeley, a great private institution, a great public institution, combining my love of history, philosophy, poetry, the law, literature, common sense, I hope, scholarship. You heard plenty of scholarship from Steve Whitty. We have a great, great group in the state engineer's office. You know these people. They come from your community. So here's my poem called Water's All About, which I hope you'll see is about Colorado. In my book, Into the Grand, published by the Continuing Legal Education, a nonprofit educational effort of the Colorado Bar Association. So the picture in this book, man waits for ditch water, and my photographs illustrate this book. Man waits for ditch water is on my son's farm. He irrigates off the Bessemer, 15 miles downstream from Pueblo, outside of Avondale. He has 30 irrigated acres, and he grows organic row crops, including 9 different varieties of garlic. I'm very proud of my farmer son, Dan Hobbs, who also works for the Rocky Mountain Farmers Union as a co-op specialist, grew up in Denver, always wanted to be a farm kid. So he's trying it out. He's trying it out. So this is taken in March a couple of years ago, and it's before the irrigation waters come in out of the lateral from the Bessemer. And you can see the furrow rows he's got waiting now for this life-giving water to just come through those rows. It's really nice to be able to illustrate a poem here with a photograph of your son's farm. Water is all about. Water is all about our work and play, how we're formed and look, from brow to toe, brain and heart, mountain front, and plains afoot. Snow white caps on winter heads, rolled up sleeves in August bake, lakes and streams that swell and shrink, that fall and spring are equinox. Gnarly hands and gnarled up knuckles, buckled plates and chisel grooves. From north to south, the hogback hues, the reds, the greens, our faults, our hopes. From east to west, the morning peeps. She plants her feet in columbine. She spreads her mantle on the utes. The canyon rims the furrow rows. She sets our route, our journey on, her waves and pools, her come along, our Colorado water. So come along with me on a little journey about how we evolved this doctrine of water law and use that Steve so well described. And I'll just signal you when I want the next slide, or go back, I'll do this. Because I want to do some of that too. All right, so this is the history, culture, and law of Colorado water. And I consider real property law to be a sub-use, a subtitle of the water. All right? How many realtors do we have? How many owners of real property do we have? All right? So I'm going to call real property law in Colorado a subdivision of the water law. Right? And the reason is, without water to put on that land, your land is virtually worthless. Except if you want a city plot that is supplied by a municipal water system, which then has to have a water. So I know I made a big statement there. I hope to prove my hypothesis. Real estate is a subdivision of the water. Now this is the inset guide to the Colorado Water Foundation's Citizens Guide to Colorado's Interstate Compacts. I am the chair of the Publications Committee of the Water Foundation, which was established by our legislature in 2002, 2003. How many of you were here then? Huge drought, right? Huge drought. Normally, our snow melt and our tributary groundwater feeding service streams produces 16 million acre feet a year of supply. You know what an acre foot is? 100 yards long on a Seattle football field. Sorry, I did go to the bowl. It was good. 1 foot deep, 100 yards long, acre foot of water will serve about 2 families of 4 a year. Okay, that's an acre foot. CFS, as you know, is the head, the flow of the water through the head gate into the ditch and out the laterals, right? It's a rate of flow. It's not a measurement of acre feet. This will become important as we discuss consumptive use. Right? So this is the Citizens Guide to Colorado Water Law. This is the inset to the Compacts Guide. There are 9 citizen guides, 33 Headwaters magazine available for you to view on the Water Foundation's website, cfwe.org. You can download any and all of the Headwaters magazines. The latest one is on the energy and water hydraulic fracturing issue. The Citizens Guide have a modest cost to order the hard copy, but you can view it online. Okay, so there's a tremendous educational resource there for you to use. Now, what is an interstate compact? We are at the headwaters where the mother rivers, only 2 streams flow into our state. The Green River comes out of Utah, makes a little curl, hits the Yampa at Echo Park, goes back into Utah. Little Snake River comes out of Wyoming. Otherwise, everything flows out. I found that out coming up here today. I forgot how high you live. Really. The last time I was here, I was bringing my Boy Scout troop from, an inner city Boy Scout troop from Denver up here to go into the Zandres. My wife used to call them the bad news bears. They were a bunch of city kids, some of whom had never camped out, you know. Single-parent families, mother-led from the Warren Village in downtown Denver, and I was the scoutmaster for 8 years. And I got this mix of kids from very elite families in Capitol Hill and these kids from the homeless shelter, basically, at Warren Village. And taking them up in the Sun Rays for a 5-day hiking trip is an eye-opener for the scoutmaster as well as for the scouts. The headwaters state, right? Our water flows all the way to the Mississippi River, to the Gulf of Mexico, to the Sea of Cortez. You take a look about the great country of the West here, huh? West of the Mississippi. Look at the sweep of Colorado water. We serve 18 downstream states in the Republic of Mexico at the boundary in the Rio Grande Basin and the Colorado River Basin with Mexico. What is a compact? It is a, what? Back up. Back up. A compact shares the water of interstate stream system between upstream states and downstream states. We have entered 9 interstate compacts to assure our future perpetual water use out of the water supply of the 4 great rivers, the Platte, the Arkansas, the Rio Grande, and the Colorado River. Right? We're the mother of those 4 great rivers. Platte, the Arkansas, the Rio Grande, and the Colorado River. The law of the United States is that you must share water with downstream states. We're a federal governmental system. There is a supremacy clause. We are one of 50 states. We are in a union. The United States Supreme Court has original, equitable jurisdiction to declare what an equitable share of an interstate stream is between the upstream states and the downstream states. If you don't want to keep going back to the U.S. Supreme Court between states to allocate the water supply of an interstate stream, you enter into a compact, which is an agreement with other states, and when Congress approves it, it becomes the law of the United States as well as the signatory states. What does this mean to Colorado? 2/3 of our water supply on average must be delivered out of state to these downstream states. We must depend upon 1/3 of the water, and now I'm talking consumptive use, the water we use up. We must live on 1/3 of the budget, if you will, of the water that is produced off the Great Divide. 1/3. We have a growing population. When I came out of law school, 1971 after graduation, back to Denver with my wife, there were 2 million people in Colorado. There's 5.5 million now. The projection is we're going to double in the next 50 years. Main lesson: we have to live on the same basic water supply that the ancestral Puebloans had, the native people had, right? And aggravated by the floods and shortages of climate change, the variability now that we're experiencing, and we're limited by these interstate legal arrangements. That's why we're basically over-appropriated. Over-appropriated. There is not new supply, basically, except in extreme flood events, if you can store it and retain it, available for new water rights in the Platte, the Arkansas, and the Rio Grande Basin. That's why augmentation plans exist. So you can divert out a priority without being curtailed by using senior storage rights, imported trans mountain water, which can be 100% consumptively used because the return flows from the prior use have not historically gone back to the stream. Let me put a point there.
You know, our water rights started when the 1859ers came out here, when gold was discovered at the Platte and the Cherry Creek and in the Pikes Peak gold field. The farmers were right on their heels. It was rumored that the miners liked to eat. The farmers dug direct flow ditches off the streams and mainstream channels of the Platte and the Arkansas Basin to grow crops to feed their families and to feed the miners. And the cities grew out of the farms. The cities are still growing out of the farms. The senior water rights were those that were established in the 1859, 1860, 1861, down to the 1890s. In a scarce water year, those are the rights in priority. Huh? 2 centuries ago, right? 150 years ago, the senior rights are established by actual beneficial use. Those of us who have come along later are subject to their decreed actual need of this great public water resource. This is a doctrine that grew up on the ground in the water-short region, which is very different from the law of England and the eastern United States. Next slide. Thank you. Now you wondered when I was going to get past the introduction. Now, when I was a water lawyer for the Northern Colorado Water Conservancy District for 17 years, the 7 northeastern counties of Colorado, the bargainer with the Bureau of Reclamation for the Colorado Big Thompson Trans Mountain Diversion Project, that was my client. Northern Water District, they taught me the water law on the on-the-ground needs of farmers and cities. I did have a short stint before that in the Colorado Attorney General's office advising the state water engineer and the Water Conservation Board, but I really learned about water from the people in Northern Colorado who hold the water rights. So I was able to pay for, on my attorney's private practice, these historical maps, some of which I'm going to show you. They all now belong to the Colorado Supreme Court because I've dedicated my historical map collection to the court, to the people of Colorado, along with my water and Western history collection. Now, those of you who must leave at 12:30, I won't be offended at all if you need to go. If you can hang with me for about half an hour, I hope you'll enjoy this. This is the 1841 Wilkes map. Now, Wilkes was a Navy captain. This was the second expedition chartered by Congress after the first was the 1803 Lewis and Clark Expedition West, after the Louisiana Purchase. Congress charged the Wilkes expedition to survey the West Coast. Now remember, the West Coast did not belong to the United States at this time. This is 1841. This is Mexican territory, right? California was Mexico. And the Northwest was contested between Russia, Britain, and the growing United States. Just want you to remember that. Our Congress sent out the exploration of this coastline when we didn't own it. We certainly had hopes in the era of manifest destiny of fulfilling what we proclaimed was our destiny, from sea to shining sea, as a growing United States. But my point is, this great country that we love, this vast interior, the Rocky Mountain states, the Colorado River's way out of line. The Rocky Mountains themselves are way out of line. The Poudre River is marked way up here in the northeast corner. The whole great plain there, what they call it? Their Great Sandy Plain. There's a little notation up here that says, I got it on the back of this Citizen's Guide. Quote, "This plain is a waste of sand with a few detached mountains, some of which arise in the region of perpetual snow, whose positions are unknown. From these flow small streams that are soon lost in the sand." And then it goes on to say nobody lives here but a bunch of miserable Indians. That will give you the view, the of what those living on the eastern seaboard thought of this area that Stephen Long had declared as the Great American Desert, and then somebody else had declared as the Great Sandy Plain. The Great American Desert being up to our continental divide, the Great Sandy Plain being over the divide. This is not that long ago. Not that long ago. Next slide. This is Mexico, before the Treaty of Guadalupe Hidalgo of 1848. Before 1848, everything from the south bank of the Arkansas around the San Luis Valley up the western slope to California was owned by Mexico. Through the Mexican-American War, which commenced in 1846, we annexed to the United States 40% of Mexico. Much of the land we love, southern Colorado, New Mexico, Utah, Arizona, and California belonged to Mexico, Spain before that. But those are all colonial powers, are they not? The land before that belonged to the Native Americans who lived sea to shining sea, North America to South America. The indigenous native populations occupied this land before the colonial powers, which gave birth to us, got their foothold in the Americas. We need to talk about our history. It's important to water history, and it's important to justice with each other about whom we are in Colorado, in the Southwest, and in the United States. I happen to think there's no more fascinating area in the world than the Four Corner states, Colorado, New Mexico, Utah, and Arizona, where we still have our native peoples and the Hispano influence and all the rest of us in the great state of Colorado. Next slide. This is the 1845 Fremont map. Who was John C. Fremont? We call him the Great Pathfinder. This map is the compilation of 3 expeditions that Fremont took into the west, up the North Platte. You see it, up the North Platte to South Pass, right? South Pass was the low break in the Continental Divide, right at the whole of the Rocky Mountain chain. The railroad went through South Pass, right, when it was built, the low spot. When it was built under the Union Congress, because the Southerners wanted it to go south, for reasons I will explain. So 1845, Fremont has taken 3 expeditions in here, and he's surveying now from South Pass down through North Park, Middle Park, and South Park here in Colorado. Right? The border here with Mexico is the Arkansas River. Your watershed. Your watershed. Because the 1803 Louisiana Purchase was up the Arkansas River to the divide to Montana. Okay? The south bank of the Arkansas was Mexico, Spain. It's Indian country. The Pawnee, the Sioux, the Arapaho, and Cheyenne. The Comanche and the Kiowa. Now that's the east slope. As we know, the west slope was inhabited by the Utes and the Navajos and other tribes. 1846, this map is used to invade New Mexico by Colonel Kearney. Fremont had already surveyed the route into Santa Fe. It was well known because the Santa Fe Trail, the watered route, came up the Arkansas instead of breaking across through the Cimarron and cut off the dry route to Santa Fe. So Bent's Fort in your watershed is one of the famous landmarks of the United States. And this opening of commerce that Mexico allowed with the Yankee traders, if you will, coming up the watered route, then over Raton Pass, and into Santa Fe. This was the era of what the United States calls the era of scientific exploration. I do want to point out to you that Fremont was employed by the United States Army. There was a strategic use of these maps and of map making for the movement in the Manifest Destiny era to go west. I'm not casting any aspersions now when I use manifest destiny. It was the term used at the time. In the one presidency of Polk, who was from Tennessee, the United States admits Texas who had taken territory from Mexico in a conflict to the Union. The Treaty of Guadalupe Hidalgo of 1848 adds 40% of New Mexico, the southwest we love, the United States. And the Oregon Treaty of 1846 adds Idaho, the Seattle Seahawks, and the Oregon Ducks. A huge mistake. I say we de-annex them. This is how we grew. This is who we are. We don't need to be ashamed of our history except when we're guilty. There was slavery practiced on the frontier by Indians against Indians, stealing of women and children, by the Spanish and the New Mexicans against the Navajos who were stealing women and children into servitude. An open trade in servitude. It seems that we've done a good job in the history of the world of subjecting other people to various forms of slavery. The 13th Amendment came out of the Civil War and abolished slavery and all forms of servitude except for servitude for a crime, punishment in jail. That's how much of a breakthrough the Civil War was. We played a huge part in the Civil War. Let me show you how, and how our water rights got established as a result of that. Next slide. I do have to pause here and talk about Lieutenant Ives. Lieutenant Ives tried to take a steamboat up the Colorado River from the Sea of Cortez to prove that the Colorado River was navigable. He proved the opposite. He wrecked a steamboat at the Black Rocks where the Hoover Dam now stands, outside of the little village of Las Vegas. He walked across to the south rim of the Grand Canyon and wrote in his journal, beware of your prophecies. Wrote in his journal, no white man shall ever come here again, it is so desolate and barren. He was standing where the El Tovar Hotel now stands. Right? He goes across with a Navajo guide. He finds the Hopi mesas, the 3 mesas. The Hopis are irrigating corn, squash, melons, and beans using ingenious systems of cisterns, yes, Steve Woody, ponds, ditches, and laterals. Like their ancestors had done, like the ancestral Puebloans had done. Right? So water law is the governance of a public resource in community for the good of the community under the customs and values and laws of those who are in need of a scarce water supply. Next slide. The upper basin and lower basin Colorado River basin states. Wyoming, Colorado, New Mexico, Utah, above the Lee Ferry Gauge, below the Glen Canyon Dam, Arizona, Nevada, California, the lower basin states, and then, of course, the Republic of Mexico at the boundary. Next slide. The Land Office map of 1902. I want you to hang in with me a little minute here. 1902 now, see? So the 59ers come out here after the gold is discovered. They flood into what was the western part of Kansas. Right? The dividing line between Nebraska and Kansas territories in February of 1861, when we're formed, is the baseline road in Boulder. The baseline. The boundary line between Nebraska and Kansas territories. Okay? So are we north of the Arkansas River here? Or south? South. Mexico. Okay? prior to 1848. Now this is 1902, so a lot's happened here. I just told you. Louisiana Purchase, you know, up the Arkansas the Divide, the Treaty of Guadalupe Hidalgo, south of the Arkansas River around the West Slope. There we go. Colorado. Kansas becomes a state in the Union Congress. The South is withdrawing. Abraham Lincoln. Try the next slide, will you? Whoop! This guy has been elected. The writing is on the wall. The U.S. Supreme Court in the Dred Scott decision of 1857 has said that slaves can never be citizens, they can never be free, they are the property of the masters, and you can take your property anywhere into the new states and territories. Lincoln opposed the Mexican-American War precisely on the fact, when he was a one-term congressman in 1845, he declaimed and decried President Polk for provoking the Mexican-American War as a slave conspiracy. Polk was from Tennessee. A slave conspiracy to transport slavery into the new western lands. Lincoln thought that the Kansas-Nebraska Act of 1854, which allowed the new territories and states only the adult white males to vote whether they should be slave or free, was an outrage. And then when the Dred Scott decision comes down, he then is back into politics. His buddies back in Illinois said, don't bother running for public office again. What he had said condemning the Mexican-American War was not real popular. His legacy to history was that he came back into public life to declaim and decry the spread of slavery to the new western lands. As much as anything, the Civil War crisis was brought about by us, by the new western territories, and whether slavery could be exported into the West. Dr. Susan Schulten, chair of the History Department at the University of Denver, has well documented this in many articles and presentations she's made, including one I attended at the University of Denver this past week. All right. Why were we carved like this? Go back. Because there's the water story in this map. Now, Lincoln runs on 3 planks of the Republican platform in 1860. He's our first Western president. By the way, Fremont ran as the first Republican for the new Republican Party, which was opposed to slavery, in 1856, but he doesn't get elected. Lincoln gets elected. What were the planks of Lincoln's platform? They were delivered by the Union Congress without the South in 1862 because the South had left. The Homestead Act of 1862, the Railroad Act of 1862, the Land Grant College Act of 1862. You get the pattern? This area added to the United States is going to be used for homesteading by free people to settle homesteads on the public domain. What is the public domain? All of that resource added by the Treaty of Guadalupe Hidalgo and the Louisiana Purchase is the public domain. It's all within the control of the United States Congress to decide how to allocate the forest, the land, the minerals, the water. Everything needed to get a toehold in this country is within the power of the United States Congress. The Treaty of Guadalupe Hidalgo required that the land title of the Mexican land grants be recognized. That was in the 1848 treaty. So you see in pink the Mexican land grants, the Sangre de Cristo land grant in the valley, the Bobian-Miranda grant crossing the boundary of New Mexico in southern Colorado, the V Hill St. Vrain grant over here on the east slope, okay, the Mexican land grants. The red dots are the land offices. This is the land map. Okay, what was a land office? If you could live on your homestead, your 160 acres that had been surveyed and was otherwise unoccupied for 5 years, you could get the title to the surface. The surface was called a patent. You get a title to the 160 acres by coming up and proving that you, your family, lived on the land. Well, you can't live on the land here and grow crops without water, because there's less than 20 inches of precipitation a year. When you cross the 100th meridian, which goes through Nebraska, the natural supply falls off, and you need at least 20 inches of natural precipitation to reliably grow crops without irrigation. So this area here needed to have a system of water rights in the public's water resource. The Congress in the 1866 Mining Act, and look around where you live, Westcliffe, Silvercliff, the entrada into the mountains through the miners. Remember, the farmers are feeding the miners. The narrow gauge railroad is built under the 1862 Act, as well as the Continental, to get the commerce up and out, right? Now it's used for, you know, hiking trails and biking trails. And, you know, wish we had this system still, you know, but we tore it up. You know, but maybe these old railroad beds are still good for some purposes. We have all this history embedded in us. So the 1866 Mining Act severs the water as a legal estate from the land on the public domain by Congress, and allows the states and territories to have their own system of water law to allocate the unappropriated water on the public domain to actual beneficial uses. So Congress, now let's be careful about our states' rights stance here. None of us got any foothold here. I'm talking about our predecessors. If it weren't for Congress deciding how we could occupy the public domain in the West, right through this series of land and water laws that allowed Colorado Territory and then the state of Colorado to have their own water law system. There could have been a national water law system, but Congress didn't do that. It wanted the settlers of the West, through their own system of water laws, decide how the water on the public domain would be allocated and used. What about the Utes? After the Civil War, the Utes get an 1868 reservation. One of the negotiators of the Ute Treaty of 1868 was their good friend Kit Carson. Kit Carson used Ute scouts to invade the Navajo territory during the Civil War and herd the Navajos out of the Canyon de Chelly and other areas because the New Mexicans were tired of raids back and forth. The Navajos were herded out to Fort Sumner on the Pecos River on their way to Indian Territory. That was where they were going to be put. After the Civil War, Sherman, the very same Sherman, is the military governor of the West, comes out here and negotiates with the Navajo, and they plead to go back to their homeland. And Sherman says, yes, if you live in peace, you go back to your homeland. So the Navajo reservation was preserved. This was the era of making reservation treaties after the Civil War because we wanted peace out there with the tribes, because we wanted a homestead on the rest. So the Utes get this reservation from the Four Corners here all the way up through the White River, the western third of Colorado. Now the Utes used to come over and hunt buffalo in the spring and summer on the east slope, and you know the Garden of the Gods was a very special place for the Utes, and you've probably seen those pictures of Utes in the Garden of the Gods. They were preserved this territory, this reservation, through this 1868 treaty, but as often happened throughout the West, the government could not keep those who wanted to mine out of the reservation. You heard about the Black Hills and the Army trying to keep out gold seekers. It was totally impossible because once gold was discovered, snipped of, or whatever found, they were out on Indian lands. So the Utes, in the Bruno Agreement of 1873, cede the San Juans, the gold and mineral area, hoping to keep the rest of their reservation. But the Meeker incident occurs where Nathan Meeker, who helped to found the Union colony, we now know was really the Union colony, plowed up their horse track on the White River. They were great horse people. He thought they should become farmers like everybody else. A few members of the tribe took exception to it and killed him. So the 4 bands of the 7 that were up in this northern part of the reservation were shoved out to Utah, and that land was put back into homesteading all the way from Ouray to the Yampa River, from the town of Ouray to the Yampa River. This explains why the water rights on the west slope are, the earliest date are 1880 and junior, right? Because you couldn't get a beneficial use water right for a farm on an Indian reservation. It wasn't until it was put back in the public domain for homesteading that that area was able to have homesteading and have water rights attached to homesteads. So when you look back in your land and water predecessor deeds, you will remark on a couple of things, right? You either do or do not have a water right conveyed by that deed. Pay careful attention. The water can be severed from the land. Remember, the United States Congress severed the water from the land and gave the states and the territories the right to create the water law. So you cannot assume, because you buy a piece of land, that it ever had a water right, or if it had a water right, that it wasn't conveyed away. You have to check the land titles, right? Now, there is a presumption that if there was an adjudicated water right, it went with the deed. It would be much better to have mentioned it. But there may have been deeds out there that withdrew, conveyed, severed the water, and those are the ones you got to be concerned about. By the end of the 1900s in the Platte and the Arkansas, there is more length of ditch built than as water can be provided in even an average year. There was a lot of ditch building and expectation, I'm going to say of good water years, or just because people were engaging in great hopes, than there is of actual water supply. Okay, what else do we have here? The National Forest. In 1891, Benjamin, now you live right in the National Forest area here, and this is important to all of us. In 1891, Benjamin Harrison is in office when the Congress passes the 1891 Forest Reserve Act. The first forest reserves include the White River, which is that big green chunk, one of the biggest reserves ever in the history of forest reservations. Now, what is a reservation? A reservation takes land out of homesteading and devotes it to a particular purpose. Indian reservation, purpose of the Indians, homeland. Forest reservation, the purpose of conserving water, and there's a United States Supreme Court case on this, preserving water for the settlers of the West, and a perpetual supply of timber. Why? Forests act as a natural reservoir. They captured that snow melt that Steve Whitty talked about. He talked about the first reservoir being the snowpack, whatever. The forest captured by the percolation into the tributary groundwater system that feeds the surface streams. Tributary groundwater and surface water are hydraulically connected, right? So when water seeps into the forest, it comes out later on during other times of the year into the surface supply that feeds these senior ditches. Now, Teddy Roosevelt, coming after Benjamin Harrison in the early 20th century, is the great champion of forest reserves in the West, the area of progressive conservation. He goes out and he camps out at the Hotel Colorado, probably did some hunting on the side. He liked to shoot. You can still buy a teddy bear in the Hotel Colorado, and it's named after Teddy Roosevelt. He stumps the state, trying to convince the farmers and the cities that we need to preserve the national forests. Why? Because homesteading allowed cutting up into 160-acre pieces of the forest, as well as the prairie ground, into private property. And you know those photos of the mining camps, right? And when the spring snowmelt comes, you know, the sediment is washing off into the streams and ditches and reservoirs because there's no forest cover. You know, they're burning it for for timber, to build the stamp mills and the houses, and you know, it's denuded. The great forester Gifford Pinchot allies with Teddy Roosevelt, the great speaker and political figure, that the conservation of the national forest is the conservation of a natural watershed water supply. And so Colorado ends up with 14 million acres of national forest, and as soon as you create one of these national forests, the bets of the Homesteading Act are off. You can't create new homesteads. That's what the reservation does. So better or worse, we've married the federal government in many ways. We are them, they are us. We are one of 50 states in a union. You know, we keep turning this worm, don't we? The national forest, as you know, is a hugely popular recreation, fishing, and other area, and it's an aggravating situation where you have to cross it to get an enlargement for your ditch or reservoir, right? Because you got to get a federal land policy management permit if you're on BLM land. There's 8 million acres of that, or water land, or a right-of-way under the Forest Planning Act, under the Forest Act. So there's plenty of regulatory overview here. Sometimes it's pretty aggravating. Sometimes it's pretty much of a blessing. 2/3 of Colorado has been conveyed away through the Homestead Act and the sales of public lands. So 2/3 of our land is not owned by the federal government. 1/3 of it is. You can call that a blessing or a curse. I call it a lot of open land that we love. We love our 1/3 of the land that is not developed because we're Coloradans. And there's two lobes of our brain, there's two chambers of our heart, of our western brain, of our western heart. Beneficial use and preservation. Beneficial use and preservation. So we have these great national parks that were preserved, right? Like Rocky Mountain National Park, the great sand dunes, Mesa Verde, you know, and then we have our development on the private land, and then we have our recreational opportunity on the public land, and then we have people using land and water trusts to keep water on the land that it historically irrigated so it won't be sold permanently off to cities or busted up into ranchettes, serving the wildlife and the restoration of streams, and other kinds of agendas that we have because we love this place. And when the railroad opened up the Smoky Hill route, the Arkansas route, and the branch from Denver up to the Transcontinental, and then up into the mountains with CF&I, the biggest industrial concern between St. Louis and San Francisco, manufacturing the rail, we imported all this tourism from the get-go. I can remember my grandfather, born in the 1890s, telling me how his mother brought him out and they went up the narrow gauge up Pikes Peak. And they went across on the train to the Grand Canyon. So Colorado has been this mechanism of resource development and tourism and recreation from the very time, starting right after we were carved like this. And by the way, why were we carved like this in this trapezoidal configuration? Ideas? Because? Man, Columbus didn't even know that. No, I like it though. The Continental Divide was put all in our territory to hold against the Texas Confederates. Continental Divide, as you know, comes out of Wyoming, goes to the Collegiate Peaks, down to around Silverton, back up on that bend, you know, around Durango to Wolf Creek Pass and down into New Mexico. This was the gold-bearing area that people knew or suspected was out there because of the 1858 gold discovery. Kansas became a state. Here's this orphan Continental Divide region with the Union Congress determining what to do with it. And they carve us into this one great state in our first mission, and it was accomplished when our miners and farmers put down their picks and shovels, sluice boxes, joined the voluntary militia, bagged the Confederate wagon train at Glorieta Pass outside of Santa Fe, and sent the Texas Confederates home. Now they've bought up all The point is, Coloradans rallied to the first great effort to save the Union. Imagine what would have happened if the gold fields were in the hands of the Confederates. Might have been a different outcome. We don't need to speculate because that didn't happen. When we were carved like this, we got the headwaters of the four great rivers along the Continental Divide, east and west, the Platte, the Arkansas, the Rio Grande, and the Colorado River. That's our heritage. We're the mother of rivers because of the way we were carved and put into the Union. And in 1876, we become the Centennial State. What is it, the Centennial State? Why is it named that? It's 100 years after the Declaration of Independence. The Declaration of Independence says, all persons are created equal before the law. That was Lincoln's political credo. Slavery was embedded in the original Constitution. You know that. 3/5 of a vote in Congress, or 3/5 of the delegation, was allocated based on black slaves who could not vote. That was a compromise to get the Constitution. The Constitution is fundamentally amended by the Civil War, abolition of slavery. You've seen the movie Lincoln. You know our streets right in downtown Denver? Lincoln, Sherman, Grant. Lincoln, Sherman, Grant. You get the idea? Lincoln, Sherman, Grant. We're a Union territory. There's a Union soldier on the west slopes of the Capitol looking out at the gold fields. I like to think he's looking out at our greatest treasure, the headwaters of the Continental Divide. So in 1861, when we first become a territory, we pass a land and water law. And what it says is that any right or claim of right to any of the resources on the public domain, remember it's all owned by the federal government, is to be considered under Colorado law as an interest in real property. I said that real fast, but hang on to it. Any right or claim of right to any of the resources on the public domain shall be recognized in Colorado as an interest in real property. A second act, I mean this is water, this is timber, interest in real property. 160 acres of land you can get under the Homestead Act, but the interest in real property the original territory was talking about was any of the public resources for which you could get a claim of right under federal law and under Colorado law. So then comes the Water Act, same territorial session 1861. Breaks the monopoly of the riparian system. Now, this is the final thought I want to leave you with. The riparian law is the law of the well-watered East in England. What it says is that landowners who adjoin the stream have the right to divert water, but only they can divert the water. And they must use the water in a de minimis fashion, and not consume it to any material degree, because the flow also belongs to the downstream landowners along the stream course. This is called correlative rights, upstream and downstream. You had to own land along the bank of a stream to be able to divert water under the riparian system. Okay? Now, this law is great where there's plenty of water and you don't need irrigation. And you use the streams to float boats up and down or float timber down or whatever you want to do. But the land that was irrigable in Colorado, a lot of it lay away from the stream. We declared the riparian doctrine null and void and substitute the law of scarcity in the arid climes where you could divert water from the stream for any beneficial use, and you could build a structure across the private land of another, and they could not prevent you from doing so because you needed to get the water from the stream to your farm. In this 1861 Act, there's only one use mentioned, it's agriculture. Why didn't they mention mining? Well, up there in the hills, when they sluiced and used water, etc., it comes right back down into the streams and comes out on the plains. And then the farmers were spreading the water through the ditches, up and down the front range, right? The water not consumed by the crop would percolate down into the tributary groundwater or come through a tailwater ditch back to the stream, and it was then appropriated by subsequent users. The subsequent users appropriated the return flow. Remember, the law's actual beneficial use of the public's water resource, administered in priority, subject to senior actual beneficial uses. Now, the triggerhead for this law being put into the Constitution, right now it's in a territorial statute, is an event that happened in 1874. The Union Colony, by the way, what's the Union Colony? It's those folks coming out to look for a township under the Homestead Act. So they came first to Colorado Springs and bypassed it. The Fountain Valley came there later. The Fountain Colony. They bypassed Longmont. This is Nathan Meeker and his group. They bypass Longmont. Longmont becomes the Chicago Colony. The Meeker people come to the confluence of the Platte and the Poudre, and they found the Union Colony of 1870. We now know it as Greeley. 1874, the stream dries up completely. Not just because of natural causes. The new settlers at the surplus Army Fort Camp Collins upstream, we now call it Fort Collins, built a new ditch and intercepted the entire flow of the stream into their new ditch. And the Greeleyites, you know what they thought of that. You know what they said? Can't you see we were here first, we built our town, we're growing our crops. You're going to extinguish us. Put the river back. Put the river back. Well, fortunately it rained in August. However, it rained in 2 years by a provision of the Colorado Constitution that fixed this law, prior appropriation, first in time, first in right for beneficial use in the Colorado Constitution. With this right of private condemnation to operate and maintain a ditch or a pipe. Now, you know when these Californians and Texans come to Colorado along the Front Range, right? And they buy one of these subdivisions where there's a ditch coming through it. What are the two things they think they can do with that ditch? They can pump the water out, use it, or they can fill it in. What are the two things they can't do? Those two things! The right-of-way is a valuable property right. The water use right is a valuable property right. It's different from a land right of 160 acres, but it's equally or arguably more valuable than the land itself. So you get why I say metaphorically that property law is a subdivision of water law in the arid West. So that's the foundations of our doctrine, and you know Steve Whitty's eloquent presentation laid out how they struggle with the administration of this doctrine. So a couple more slides and then I'm going to take questions here. Okay? One more, keep going. That's the snake diagram that the state water engineer, these are statistical averages. All right? You can see what the water is delivered out of state under the compacts. Those 9 interstate compacts, you see that bulge on the Colorado mainstream? 70% of the native water supply at the Leaf Ferry Gauge below the Glen Canyon Dam is contributed by Colorado. We can only use 1/3 of it. We move a bunch of that water east because we have these puny plain streams. You know, the Platte and the Arkansas and the Rio Grande, and we have 85%. By the way, the Rio Grande is east of the divide, correct? Right? 85% of our population is on this eastern flank. 85% of the available water supply contributed by nature is on the west side. We're one state. We have one water law, but plenty of water law disputes. Next slide. That's a hydrograph. You know this because you live up here in the snowpack, right? April, May to June, July, that's when the bulk of the water comes off. Otherwise, we sort of go flatliner. And in the 2002-2003 drought, we're absolutely at the flat line. In that year, 2002-2003, we have 6.5 million acre-feet of live storage in Colorado and about 2,000 reservoirs, small and large. We evacuated 6 million acre-feet, coming within 0.5 million acre-feet of our live storage because we had 1/4 of the water supply of a normal year. In that year, we came perilously close to evacuating our treasure house, the storage water in that year, because of our delivery that we owed to downstream states. Hey, This is a pretty picture, isn't it? Just look out your back door. You know, you live in some of the most glorious land that I think is the beginning of the country. Others think it's the very end. Right? They don't understand who we are, what we are, why the hell we live up this high. And why we would live in the land of perpetual snow except those years when there isn't any and we're sweating it. Okay, questions? Thank you. Around, and if you have to go, please go, but I'll take some questions. Now, I can't solve your legal problems because I can't practice law under the canons of judicial ethics, but I can answer hypothetical questions. All right, so don't tell me about your current water dispute that we may see. I don't want to be disqualified. Okay, yes, here, I'm going to pass you the microphone.
As a former golfer, my question is, at what point will golf courses go away so that the rest of us have water to drink?
I'm going to assume that that golf course has a water right, or wouldn't be putting water on the golf course. The answer is, that will go away when the water right owner is either curtailed because it's a dry year, or that water is bought by somebody else and transferred in the water board. You have to understand here that judges like myself cannot pick and choose whose decree to enforce. Now, I often hear, and this usually comes from Midwestern or Eastern professors, and I've had to debate them at the University of Colorado or the DU Law School, and here's what they say. We have plenty of water if we just prohibited the farmers from growing alfalfa. Because alfalfa is a water-consumptive crop, and we'd all be able to enjoy all the water we need for recreation in cities if we just tell the farmers. Now, I hope one thing that I said was it's a property use right. Under the state and federal constitutions, we must respect the property rights of individuals, including their water rights. You know, I'm a judge, I take an oath to do that. The government doesn't have any power in the face of a decreed water right for irrigation use to tell a farmer in any given year what he or she can use the water right for. I would put golf courses in the same fashion. Lots of us enjoy recreation on a golf course. We have communities built around it. It becomes open space. It becomes an amenity. We are a grassroots government in Colorado. We've loved what the federal government has allowed us to do, and we've told the federal government at the time, butt out. And I will say to you that now, unless our Constitution is changed, and then we'll have all of these confiscation cases in front of us, if we ever have a situation where the courts or the legislature tries to take other people's water rights without just compensation, we've got a constitutional crisis in this state. So the answer is, if the golf course has a water right and it's in decreed priority, as long as they want to maintain a golf course and people want to use it, it'll be there. Now, we like to condemn Arizona for having golf courses and Nevada for having fountains. They can use their compact allocation for anything they want as long as they leave us alone. Right? They don't interfere with our perpetual right under our compacts. Their choice of their citizenry under the state and federal constitutions is their choice. That is my personal view. Now, is conservation going to be needed in all states in view of this population growth? I would say yes, and it begins with municipalities. It begins with municipalities. I'm sure farmers are going to have to do that too, but they don't have the wherewithal to put in a lot of drip irrigation like they have in Israel. Do they? Nobody's offering to pay for that right now. And they're guaranteed at least their consumptive use. Because the measure of a beneficial use prior appropriation water right is the measure over time of the actual beneficial use, wet year, average year, dry year, quantified in number of acre feet of consumable water in a water transfer proceeding in the water board. That is the block of water which has been used out of the public water resource for an actual beneficial use that can be changed or transferred, leased, or sold under our system subject to protection against injury of downstream people who have depended on the return flows from the upstream uses. I've packed a lot in that. I hope it helps answer your question. I'm not a golfer, by the way. I prefer bowling. Yeah, question.
The microphone's working anyhow, but so we've spent a lot of time talking here about rivers and stuff that flows downstream, and perhaps because of my age, I'm fairly naive in the real world of agriculture. But over the last few years, I've discovered that in a lot of ways, surface water and management of the land is often all you need to produce quite a bit of food from what we call marginal, non-irrigated land. So let's take a step onto what we consider surface water, and where are some of the rules and legalities of that. My belief is that if I manage my land correctly, not only can I retain more water in the soil, but that a lot of the springs downstream from me will actually flow better because of that better retention higher up. So I guess my question is where does surface water play into this?
Surface water has the senior rights. Okay? So you are doing exactly what a junior needs to do in a water-short area where you don't have to create water rights. Take advantage of whatever natural moisture you have. Some of these conservation practices of the 30s turn out to be pretty good. So the law doesn't interfere with the surface moisture, right? But you can't just capture water that would otherwise go to the stream, because downstream ditches, typically surface ditches.
I don't even have a stream within 5 miles.
All right, but see what I think you've described to me a system of dry land farming, and we have successful dry land farmers. So have at it. You're young and brave.
I just didn't know where the water rights fall on that type of thing.
The moisture, look, we don't allow, and some subdividers have tried to do this. We'll cut the vegetation, we'll pave it over, and therefore we're producing water. And every one of those schemes has been killed by our court in the legislature, because you can see what the implication of that is. We would denude the eastern plains of vegetation to create water, out of priority water, for developers who are going to sell the houses and then leave. We don't allow that. So we have in our water law a balancing of land and water resources to prevent that. That doesn't mean you can't have creative dry land farming. I think you're still on the frontier. I mean, the eastern plains, we have areas of dry land farming up there. Now, the Ogallala Aquifer is a problem. You know, that's water that's being mined or depleted faster than it's being recharged. And some of those places are forcing people to come off of those wells, or they can't get new ones, into true dry land farming, which is periodic farming, right? All of us would agree that that is periodic farming. And it is an important niche, and to me it's important that rural areas survive, and that permanent transfers of water don't completely go over to municipalities. That's why the legislature has allowed leasing, crop rotation fallowing, and other measures to keep the water rights in the local ditch companies, but allow a supply of funds to come back to them while they lease a package of consumptive use water to municipalities. And also we have a market where the in-stream flow program can benefit from leases or sales of senior agricultural rights to those uses. But all of those schemes depend upon enforcement of this priority system. You with me? Because if you don't have enforcement, a junior is as good as a senior, and you have a classic tragedy of the commons where there's not enough water for anybody to use. That's why Greeley ran upstream as fast as they could to Camp Collins and said, put the river back. Other questions? Yes?
There's a move afoot to amend the Constitution, I think, to change the fundamental way the water law applies. Can you explain?
Well, okay, this was a ballot title a couple years ago that I dissented from.
It seems like it's going to come.
This is the public trust act.
Yes.
And the proposal was that judges be able to determine whether or not the public trust required in any given year or in multiple years, water to be kept in the streams for environmental recreation. You with me?
More than that.
And it allowed access across private property to the stream to flow. Right? And it allowed access along the banks of the stream to be able to get out of the stream, having, come into the stream maybe from the public. I thought there were 3 different titles. And our Constitution allows only one subject matter, but the court disagreed with it. So, I'm not here to debate the public trust. If you want to see why I disagree, read my dissent. In that case, I do believe that if the public trust doctrine of that type were instituted on the top of existing property use rights, there would be a crisis of just compensation claims for the taking of water rights, which I say in that dissent. Now, they didn't get enough signatures. I don't know that it's been put on the ballot this year. The mainline environmental groups don't support this. And they don't support it because they're working with the in-stream flow law, which I described, which allows the Water Conservation Board to have in-stream flows between upstream and downstream points, and allows the market and water and lease and permanent transfer to put water in the stream in sections to augment the junior in-stream flow water rights. Where's the water come from? These senior ditches. Why do we have land and water trusts? To keep the senior ditches in operation on lands they historically irrigated, so we don't bust up those great hay ranches. I keep coming back to that. The great amenity that we've discovered in Colorado are these great hay ranches, and families that agree to put on a covenant to preserve that open space and wildlife benefit and work the stream restoration aspects as well. They're doing a heck of a job in the Rio Grande. I understand there are trusts in the Land and Water Trust. These are voluntary mechanisms working in the Arkansas. And we have communities in northern Colorado. Remember when Governor Romer discovered smart growth? Remember when he discovered smart growth? You know what smart growth was? Cornfields between Boulder and Longmont and Fort Collins. And those communities are buying the open space and keeping the original water rights on that open space and then leasing out to farmers to grow crops so that it's not all filled in like LA and Manhattan and Tucson, and maybe not Tucson, Phoenix, where they're sacrificed their agricultural industry in that state for growth. And so one of the great debates in Colorado right now is, do we want to keep agriculture in production in the rural areas? Or are we just going to have a market system that moves the water to cities whenever they want? That is what's going on right now in this great debate. And have at it. It's fun. I'm a judge. I'm just going to wait and see what happens. Yes?
In a bigger picture outside of Colorado,
Yeah.
that may affect Colorado.
Yeah.
With what's happening in California, do you see them asking or requiring or demanding that Colorado give more than they already do?
Well, absolutely.
And will we?
They like more. They're not going to get more. But they like more because they're oversubscribed. Their allocation is 4.4 million acre feet under the 1922 compact. They've used up to 5.3 million acre feet a year. The compact allowed the lower basin to use it so long as the upper basin didn't use their full entitlement. So they weren't acting illegally. They just got dependent on water that belonged to the upper basin states. So yeah, you remember why John McCain, when he was running for president, when he went and made that speech in Pueblo, and everybody said, go back to Arizona on a bipartisan basis. You remember what he said? He said we ought to renegotiate the Colorado River Compact. Well, this is the Phoenix Chamber of Commerce view. The only people that can win are the lower basin because they have a greater need and they're oversubscribed. He was unwelcome by both main political parties and most Coloradans because, it was like, who fed him that line? Am I wrong about that? You guys remember this? You've got to be very careful for your speechwriters. I'm not going to be cavalier with the answer. We've got a crisis. We're in the 14 years of drought now. The Bureau of Reclamation for the first time is going to cut down the delivery out of Lake Powell. Right? The normal delivery is 8.3 million acre feet a year. We have guaranteed to the lower basin 75 million acre feet on the 10-year running average. That translates to 7.5 million acre feet delivered out of Powell. We've taken out off the top of the river, because of the 1944 treaty with Mexico, 1,500,000 acre feet that we owe to Mexico at the boundary. So the Lake Powell is operated to deliver 8.25 plus 7.5 million acres feet a year, plus half of Mexican freedom. This year, because of ongoing drought, there's going to be less water delivered out of Lake Powell. If that happens multiple years in the future, we're going to have this problem of a compact call, where the lower basin will go back to its entitlements and then ask that we be curtailed in the upper basin so that this 75 million acre feet on the 10-year running average can be delivered. That's why we have Lake Powell for the good years, to store the water so we can equal it out, right? Yeah, now who in the back now wants to talk to resident Tucker? Did I get one of your questions or not?
You did, but I wanted to.
Okay, yeah, well, let me go to somebody else first. Who else? Yeah.
My understanding is that the Nestle Corporation has become one of the biggest owners of water rights in the country. How is the corporate influence on on this going to have an impact in the future?
You grow hot potatoes? Okay, here's my view on this, okay?
I'm one of those
Yeah. If you want to get after the Nestle Corporation for bottling water, you're going to have to get after the beer suppliers for bottling beer. Beer is water in a canteen, fermented. Nestle's doesn't ferment it. They still put it in a canteen. They do it within Colorado on a water supply that has a decreed water right or an augmented priority replacement water right. I, as a judge, don't get into morals of bottled water. I think it's terrible we have all these plastic containers floating in this big vortex in the Pacific Ocean. You know, and I prefer, you know, I have a canteen. You know, I'm a Boy Scout. I fill it from the Denver Water Board source in my office. But I'm going to leave that up to consumers. Soda pop. Soda pop is bottled water. I mean, how can we condemn a corporation that makes beer and soda pop? How do we condemn Nestle's without condemning all other forms of beverage which we like to buy at the 7-Eleven? I just don't get this argument. I'm sorry. It's not a legal argument. It's some kind of moral, ethical argument against corporations. I told you we have an anti-speculative law because the great fear of the founders of our water law was that land companies would buy up the land along the banks of the stream and control the water. So our people, when they passed the Constitution, were anti-monopoly, anti-corporate, anti-speculative. But what they were concerned about was preventing others from actually the need for the use of water. So if a corporation needs water, we got all these microbreweries. I don't see any principled way to say yes to them and no to this. Oh, he's passing you something. I hope that's not too cavalier, but I think it responds. What else? What else? Yeah? Kansas. Did you say Kansas?
Yeah, the water running down through the Arkansas to Kansas. Why? What happened that so much of it has to be sent away?
Thank you. We had 3 different litigations with Kansas, and this original equitable apportionment doctrine came out of Kansas suing Colorado in 1902, and the U.S. Supreme Court decided in 1907. Kansas was a riparian water state, so they claimed that we had to pass the water to Kansas undiminished. Colorado said, no, we're a pro-appropriation state. We got admitted to the Union in 1876 under the Equal Footing Doctrine. Everybody knew we had prior appropriation. Kansas, you get whatever is left, you know, after we've used it. And don't worry, there's going to be plenty of it. We won't need it all. You can get some. The U.S. Supreme Court in that litigation said, no, the law of the United States is equitable apportionment. between upstream and downstream states. This is not a matter of state water law. They must share this interstate resource. Well, having gotten tired of 3 rounds in the U.S. Supreme Court, Kansas and Colorado entered the 1948 compact. And that freezes the water use between Kansas and Colorado based on 1948 conditions of delivery through the John Martin Reservoir down to Kansas. That's the regulated reservoir for Kansas. Well, what happens? We don't regulate the pumping into the tributary groundwater. And remember, the tributary groundwater is connected to the surface water. Tributary groundwater is any water which within 100 years would migrate to the surface stream, or the depletion of which through a well or surface diversion would deplete the surface stream within 100 years. That's our guideline. So we have all these out-of-priority wells drilled into the tributary groundwater of the Arkansas River, and Kansas blows the whistle before the U.S. Supreme Court and says Colorado's consuming more water than they're entitled to, and Kansas wins. We spend 22 years fighting that. We win. Why do we win? Because we lost. Kansas wanted $170 million. We got away with paying $38 million. It was a heck of a deal. We stole their water for years. And we didn't even have to, the farmers didn't even have to pay for it. Because the state of Colorado is the signatory. The state of Colorado Treasury had to come up with the $38 million that the U.S. Supreme Court said that was owed. But the result was that ongoing compact compliance was ordered by the U.S. Supreme Court, so we have to regulate the out-of-priority wells. So that's how we got strict administration of the out-of-priority wells that we were just kind of drifting by, especially through the 50s drought. The 50s drought gave rise to huge pumping in the tributary groundwater of the Platte and the Arkansas because of the invention of the high-capacity irrigation pump and rural electrification, which was a 1930s progressive reform, just like the conservation of the soil when Lenth was a progressive drought-era conservation reform. But we felt there was all this bank of stored water, but it turns out that it's tributary water that feeds the surface stream, that feeds these senior priorities of the senior surface rights that date back to 1860 and 1861. So we find ourselves, as usual in the water world, coming and going. That's the long and short of it. We lost. And we lost to Seattle.